final matter to come before us this morning is bias versus bias. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve that time, let me know. I'm keeping the clock this morning. We've read the briefs and we're ready to see when you are.
Thank you, Judge. Again, good morning, judges. Good to see you again. This particular case, I think, is just one of plain error, which really is the only way that I guess it will survive itself here. The argument is very simple. If the court decided to, even though the objections were outside of the 14-day period of filing, to issue an opinion, and I found an opinion from another court of appeals, a different district, that indicated if that was so, that in fact that court did proceed and issue an opinion upon what had happened at the lower court. In this particular case, the court, in its entry, the trial court, talks about when an order is issued in a CPO case. This one, though, is different in that it is in fact a consent decree between the contesting parties. And in the consent decree, the petitioner in the case agrees to make certain financial obligations payable to the mother of the respondent, as she is the one who had signed for the car loan. And it just seems wrong that we have courts accepting it because there's clearly an acceptance by the court of the agreement of the parties. I mean, the transcript is replete with that. So I think what we have is in fact plain error. I believe that the trial court has misguided itself, and as such, I think that the case is of substantial public interest. As I say in the brief, petitioners could willy-nilly agree to anything just in order to get the CPO without a merits hearing. And the respondent, in reliance upon that, then enters into the consent agreement believing that the obligations that the respondent, that the petitioners accepted will in fact be enforceable by a court of law. And to allow this to go unchecked, I think, is unwarranted. And I would ask that the court would issue a decision. I mean, that's the argument that I've got. Very simple, very straightforward. It's not an order issue. It is a consent decree. And I believe that throughout the range of this particular court of appeals, that putting out that decision would be appropriate, and that all domestic relation courts and the 4 counties associated with this court would in fact follow what is supposed to be done. That's it. My argument is short. I reserve no rebuttal. I don't know if the court has any questions or not.
Seeing none, thank you.
Thank you.
Good morning, judges. My argument is simple. It's very simple, as evidenced by the brevity of my brief. I don't think I've ever filed that brief. The issue is jurisdiction, I do believe. There was no extension of time requested nor granted to file objections. It's clear that the objections were filed outside of the 14-day requirement under Rule 53. The argument plaintiff makes in the judge's, or I should say the appellant makes in the judge's order of May 30th, my response would be, when the judge is on the second page says, Mr. Bias' objections are not timely filed and should be dismissed, even if he had timely filed, his objection lacks merit. That's the end of the case. I would argue that the rest is simply dicta, even if, and it didn't give the court, I should say give the appellant, additional time because he did not object to any of these on the magistrate's recommendation, and any argument of whether it's a, quote, recommendation or a decision. I haven't seen that argument before. I believe that the magistrate was clear in stating this was the case, these are the issues, this is the decision of the court, whether it be a recommendation that was followed by the judge or not. So I really believe that absent the filing of objections within the 14-day period, preclude these arguments being made on appeal.
So let me ask you a question.
Yes.
Because this document doesn't expire until September 6, 2018, and the order is in there for this to occur monthly until apparently September 6, 2018, that doesn't preclude him from filing again, that there's continued non-payment for future non-payments, right? This only is
I
for
would
past non-payments.
probably say that might be a valid argument to be made by opposing counsel if he so choose, because they would, I believe they would be continuing payments, and that's a continuing obligation. Now, whether or not that raises the issue of the substance matter of the magistrate's recommendation and ordered by the court, I don't know, but once again, I think that was waived by not filing objections. I don't know how you extend the period of time under what basis.
What about the plain error?
Well, once again, you have to get to the merits of it. Is it plain error? And for the sake of argument, does the court have the jurisdiction to delve into that?
Well, then,
Yeah.
the argument is that they didn't have jurisdiction to order to begin with. So it's not a valid consent order either, consent. Because it clearly says hereby further ordered,
Mhm.
right?
True, true. But I guess my argument
And
is
jurisdictions
as
never
simple
waived.
as there's jurisdictions waived, and maybe had it been filed in a timely manner, there would have been issues, and there would have been discussions and arguments over a consent vis-a-vis, maybe a finding or maybe a hearing. But how do we do that?
But my point is, I guess what I'm getting at is, if you're saying it didn't have jurisdiction to ever enforce that because it wasn't, then that goes to jurisdiction to issue the order to begin with. They
Could
didn't
be.
have jurisdiction to do that, so that's
Could be.
never waivable. So where are we back to? What are we back to?
Maybe we're back to another, as Judge Schaefer brought up, if payments haven't been made.
But I'm
we can
getting
do
at
this
the
again.
plain error argument. I don't know.
I guess you would have to determine whether it was plain error or not. I just don't feel it's there to even look at, but.
Because it's a consent decree, didn't both parties participate in coming up with an agreement?
I do believe so based upon the record, yes.
Okay, and
I
did
was-
they rely on each other's representations at that time to come to a consent decree? So nobody went to trial on this, it was an agreement, right,
Correct.
to avoid having to go to
Correct.
trial.
But I think what the argument is, or at least what the court's position was does the respondent have a right to raise this because the payments were to be made to the mother? Had the respondent been sued by the mother somehow to bring her into the case, but she's not in it? And can he, and I think that's what the court was saying, can he raise that?
I thought the court was just saying because that was the respondent that they couldn't couldn't order
Right.
her to do anything.
Right. But once again, and I hate to keep coming back full circle, and obviously if this court feels it's plain error, but I don't know that. I think it's a lot more intricate. And so I guess the decision is to either remand it back or say, how about file another motion? And I guess it's up to the court as to how we'll get back to the trial court. Like I said, my opinion is those arguments were lost by not filing your objections. That's obviously for the court to determine. That's about it for me. Thank you.
Thank you both for your presentations this morning. Court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website. We are adjourned until Thursday in Summit County.
Thank you, Madam.
Thank you both.
Goodbye.
Stay warm.